Okay. So, dear friends and colleagues, welcome to yet another Belgrade Legal Theory Group meeting. Today we have the pleasure of welcoming Professor Sebastian Reyes Molina from the Maastricht University. He specializes in a lot of interesting fields, for example, in evidence law, constitutional theory, meta-ethics as well, epistemology, and so on. And today he's going to talk on a topic titled Augmented Justice, a case of legitimate authority. Always provocative and for sure interesting. So without further ado, you have 30 minutes for the presentation, and then we'll proceed with the discussion. And thank you for being with us.
Thank you, Saba, for helping me out with all the technicalities, and Boyan for being kind enough to invited me to present here. I'm very happy to get to talk to you about this. This is a new paper that I'm actually writing. It's the first time that I write a paper like this, and I'm going to explain why it's so kind of special in terms of structure. And I'm looking forward to not only talking about the paper, but also to hear your comments and your criticisms or your objections. And if you can help me out to improve the content of this talk, it will be greatly appreciated. So yeah, all the questions are, I'm very happy to hear your thoughts about it, and as many questions you have, the better. So I will share now the presentation, and can now it should work. Can you see it?
Yeah.
Yeah, great. So there is a technical complication here, because now I cannot see you. I can only see the presentation. So I feel like I'm flying solo here. But anyway, know that I will imagine you reacting to all my jokes and all that stuff. So the title of the presentation is called Augmented Justice. Augmented Justice is a thought experiment that I tried to craft with aiming at, I would say, clarify our intuitions and our worries about the possibility of AI adjudication. So basically, the idea is that there is a government program called Augmented Justice that is a feasible alternative to replace judges as AI adjudicators. There is a lot of work about the usefulness or dangers of using AI, different techniques of AI for decision making and the law. We can see this very clearly, for instance, in terms of evidence law and people that favor certain views of evidential reasoning, such as Bayesian calculus, which is basically you might be acquainted with it. With this, it's the idea of calculating the probability value of a hypothesis in conflict within the trial. So we want to know something has been proven insofar as reaches certain probabilistic threshold, and Bayesianism is an alternative to develop this way of thinking, and how can we calculate probabilities and so on, since there are a lot of problems in terms of feasibility, because we are very bad at calculating probabilities. Proponents of this view also try to advance certain parasitic views about, well, we should use tools such as AI to calculate these things. So there's a lot of debate about this, also about democracy studies, and the idea of there's also some sort of idea of augmented democracy, in the sense of, like, maybe we can use AI to improve our democratic decision making, and thus convey our worries and our needs and our desires to our representatives in a better way. But I try to bring all this discussion to to adjudication, right? And the thought experiment is constructed in a way that in which we can avoid the usual pitfalls of AI decision making, of course, AI hallucination, and tries to shed light on our intuitions about the betterness of enhanced decision makers. For those who are acquainted with Jurassic Park, there's this beautiful quotation about whether we should actually, even though we can use AI, or in this case, we can use DNA modification, whether we ought to use it, right? Your scientists were so preoccupied with whether or not they could, they didn't stop to think if they should. So this notion of should, this shouldness, let's say, is what I aim to tackle in this paper. I'm not particularly worried whether we can actually use AI, or actually AI has the capabilities of being an adjudicator, of creating decisions or producing decisions in a specific way. I'm just kind of moving past that and say, like, if this is possible, should we do it? What are the problems? And it seems that intuitively there are certain objections against using AI as adjudicators, and I'm trying to figure out why, what would be the problem. And this is a bit what I want to talk to you about today. So the content of the presentation is, first, I want to kind of establish the worry, why the worry that will give birth to this augmented justice scenario, then try to talk about a bit of the thought experiment, then present certain objections to what the thought experiments advance, then answer those objections, and then ended up with something that I call the adjudicator's puzzle, which I would really like to hear your thoughts about it. I mean, the main idea is to think that, look, we might be, there might be a possibility, or we might assume that it is possible that AI can replace human courts. And even if that's the case, then we might have problems with it. And this is the part of the objections on the presentation. But when I try to spell out these objections, I realize that all of these objections, that they are very powerful and plausible, they can also be applied to human courts. So here is where kind of like this kind of picked up my interest, in the sense of, well, you know, either we stand by our objections and we reject AI adjudication, but we pay the price that also we should reject human courts, or we don't, and we try to figure out actually a proper argument. We acknowledge that these arguments cannot be held without paying this price, and we actually figure out what is the main worry. If all our objections have been removed and there is still a persistent worry, we would like to know what it is, but beyond the idea that it could be some sort of fear that the machines will rise up and enslave us all, right? We want to have a proper argumentative apparatus to contest the idea that we should use AI as adjudication, right? So the problem typically is like, well, you know, judges are weak spots in the administration of justice. They can be bribed, can be biased, they have epistemic shortcomings, they get tired, they need to rest. There is a bunch of things that legal philosophy, sociology of law, legal anthropology have said about courts. And in this case, you know that I use also not only judges, but it can be extended to any official that have a adjudicative competence, that there is a lot of problems with it that might affect the task itself, right? And there are like legitimate worries regarding to how can we fight this, right? For all of you that are acquainted with legal realism, all these things that are, all these weak spots that I'm mentioning to you might kind of be intuitively plausible if you are also into legal epistemology. you can also figure out that regarding the decision about facts in law, we also have these problems of biases or the epistemic shortcomings, and that will presents themselves as obstacles in or quest for justice, let's say, and adjudication. Of course, this has this idea that ultimately adjudication has some sort of relationship with justice. I don't think that this is an implausible idea to have. This is revealing the way that we put together our institutional designs, the way that we talk about the law, the intuitive everyday conversations. I mean, in many jurisdictions, for instance, Supreme Court judges are called justices, right? In Chile, the three courts are called the Palacios de Justicia, the Palace of Justice. So there is some idea that law and justice are related, adjudication and justice are related, and adjudication is kind of the prime task of courts, right? So there are these weak spots, and maybe they are valid or not. There might be some exaggerations or not. But if we really take seriously that we have a lot of problems when establishing a adjudicative system, then we might also try to look for a solution. And in this particular context, the solution that the thought experiment it brings is replace or use AI as adjudicators. And the solution here is the Augmented Justice program as an AI-driven initiative aiming at replacing courts with AI adjudicators. Okay, once again, this is a thought experiment, but still, I learned whilst writing this paper that there are some countries that they are starting using AI in courts as a way of deciding a specific set of cases. Of course, I want to take this to the extreme and just say simply, well, we're going to replace courts altogether. So AI in this case, or augmented justice program in this case, will be in charge of deciding from parking tickets to capital punishment cases. So the thought experiment goes as follows. The Augmented Justice program uses large language models and large reasoning models to train personalized avatars from human judges that can act either as adjudicators or as an outsource of legal reasoning, providing human judges with solutions to individual cases. Right? So avatars can map out the preference, backgrounds, and past decisions of their human counterparts and combine them with access to legal databases and a vast array of relevant academic knowledge produced to these days. The avatars are both deliberative and dialogical, and the success in achieving just decisions is 99% of the time. Okay, so imagine that once you get appointed as a judge, you get this fancy cell phone, and in this cell phone you have this app that's called Augmented Justice, and where you need to create a profile and you create your avatar, your AI avatar. And the fact that they are dialogical, it means that the avatar can converse with you, can talk to you, to learn more about your preferences, and also will have access to your past decisions, will have access to all the legal database of your country, and if you are in the European Union, also the European Union, so any basically relevant legal material, plus the legal knowledge, so all the knowledge of legal philosophy, all the philosophy, political science, and so on, everything that is relevant for decision making. Also, their avatars are deliberative, which means that they can talk to each other, to other avatars, and try to come up with decisions to individual cases. And in this scenario, we know, as a matter of fact, that 99% of the time, just decisions are achieved. And then you might wonder, okay, but what is this all just decisions idea? Here I just take a hold of kind of not the word is not widespread, but I mean well-known and plausibly accepted views about what constitute a just decision. This, for instance, you have since Bentham, you have this idea of rectitude of adjudication, in which which is the aim of the legal process, and so a just decision is a decision that has this property of rectitude of adjudication, that basically means to interpret the law correctly and apply it to a set of facts that obtain, right? Then you move forward to evidence law scholarship, for instance, where they typically claim, like William Twining, Michele Tarufo, Jordi Ferrer, etc. They have this idea that justice, a decision that is just, is a decision that has three conditions: necessary conditions and necessary and sufficient when they're taken all together. The first one being apply the law to facts that obtain, so true, true propositions of facts, the correct application of the law or the interpretation of the law, and following a specific procedure. I tend to favor more this Benthamite view, so I just simply say by just decision is a decision or adjudication that fulfills two conditions: the effective ascertainment of the truth of the disputed questions of fact and the correct interpretation of the relevant sources of law. For this notion of correctness, I just simply defer to what Oliver Krona has advanced. Correctness is just a way of interpreting a practice in light of a identifiable cluster of rules. So in this case, interpretations that might be considered to be correct are those that they are interpreted according to the interpretative code of a particular jurisdiction or legal system. Whether these are moral or not, I don't have anything to say at this point in time. I will talk about morality and justice and moral realism later on in this presentation. But as it stands, just like if you want to know what a just decision is, it's a decision that fulfills these two requirements. So augmented justice excels in both accounts, which means that 99% of the times get the right decision about the facts. And they are also, by the way, epistemically justified. And the same thing has to do with the interpretation of the legal status, typically yield correct results, and also it provides the proper justification to at least achieve, the acceptability threshold of decision making. Right. And but however, augmented justice has two different varieties. So or two different, let's say, initiatives or directives. So you can get the Hercules package or the Hercules program and the Socrates program. And the Hercules program provides the legal system with an authoritative decision along with their justification. So legal systems that adopt Hercules will effectively replace human adjudicators with AI adjudicators. Right? Socrates, on the other hand, provides a legal system with recommended decisions and their justifications. Legal system that adopts Socrates will effectively outsource legal reasoning, so human adjudicators can either accept or reject Socrates' recommendations. However, if they opt for rejection, courts ought to provide grounds for their decision to do so. Right? So augmented justice you can hire or you can pay for the Hercules package or the Socrates package, right? I believe that ultimately the objections against augmented justice will cover both, even though Hercules and Socrates have a different sort of intensity in their adjudicative task. Yeah. So in this thought experiment, we know for a fact that 99% of Hercules and Socrates' decisions are justice in the terms of the previous slide, right? The effective ascertainment of the truth of the disputed questions of fact and the correct interpretation of the relevant sources of law. Adjudicative decisions, this I already said it, sorry. Carried out by augmented justice are grounded on the true description and the correct interpretation of legal rules, and also enjoy a sufficient degree of justification in both scenarios. So they are not only internally justified, but also externally justified. And we also know that, unlike human courts, Hercules and Socrates continuously produce just decisions over time. We can use this idea of machine learning, right? It optimizes its decision-making process in terms of fastest and also more accurate, right? So this is the idea. Here we have this idea that we are selling. Actually, we can actually augment the level of justice of decision making of a specific legal system by using this tool of augmented justice project, right? And it sounds very good. It's very successful, and we can avoid all the pitfalls of our human courts, so we can reduce very efficiently false convictions, false acquittals. We can actually avoid a lot of the problems of legal interpretation. So here's the solution. This is the package. Would you go for it? Right? Some staunch proponents of AI would say clearly, yes, of course. We don't care about human courts. We just care about justice, or that's something that, or achieve just decisions. But also there are plausible concerns about using AI as adjudicators in a legal system. And the paper will revolve around these concerns. So, however, would you go for it? Well, I don't know. We can still have objections. We can still advance objections to augmented justice. Like, think about it. Like, you can have everything that you wanted in terms of justice for a legal system, but we can still have this concern, this intuitively concern about whether we should use it or not. Remember the shouldness side of the quotation of the Jurassic Park slide. And when I tried to figure out what sort of objections could we advance, I first do divide between putative objections and plausible objections. Putative objections are those of the sort that aim at questioning whether augmented justice can, as a matter of fact, identify relevant sources of law to adjudicate. They are concerned with the plausibility of AI to replicate the practices of the members of a legal community, which is something that in this paper I'm not worried about. I'm just assuming that this is the case, right? So all these objections on the likes of like, well, but actually can they interpret, can AI actually grasp the complexities of human rights? This is a set of objections that for the purpose of this paper, I'm not going to deal with. I'm just assuming that it can. So now we need to figure out this plausible objection scenario, in which are of the sort that aim at questioning the acceptance of augmented justice, even though its decisions are just. So even if we accept that we can get everything that we want. And as it stands, I found 4 plausible objections, but of course, each objection has a counter objection, and ultimately each objection can be applied also or extended also to human courts, having this dilemma that I mentioned at the beginning. And I would, in the Q&A, I would love to focus also in the crafting of the thought experiment, because maybe I'm missing something, or maybe I should add something, but also the crafting of the objections. Maybe there are more objections than I'm not seeing. I'm not saying that this is an exhaustive list, but I'm saying that this seems to me the strongest one, and I would love to hear whether you agree with this, whether I'm missing something, or whether I'm maybe reconstructing wrongly one of these objections or counter objections. So the first one is legitimacy. And one source, of course, well, we have a bunch of sources of legitimacy. We have, consent. We have voting, this idea of political will, but also we have knowledge as a source of legitimacy. And in legal philosophy, typically, we tend to acknowledge that the one source of course legitimacy is knowledge. Courts enjoy some sort of special epistemic status that serve as ground for their legitimacy, and also why would they be entrusted with adjudicating conflicts. But knowledge of what exactly? Well, they, through the training and experience, they develop some sort of expertise that ultimately produces knowledge of the law within a specific legal community. But this knowledge is supposed to, this knowledge of the law, which is the knowledge of what are the sources of law, the legal doctrines, the past decision, the use of interpretative codes, the identifying the legal principles, and so on, are meant to do something with it. So it's eminently practical, a practical knowledge, and this knowledge of the law is aimed at adjudicating cases when you are a court, of course. Knowledge in this sense might be equated with expertise. That is the know-how about adjudication justly, like how to adjudicate justly, right? If we have this in mind, which is, of course, one of my assumptions, that justice and adjudication are related, and adjudication is a way of advancing to some sort of obtain justice within a legal system. So knowledge as expertise is the proper use of legal sources and relevant information to obtain just decisions, and this is the source of legitimacy. This knowledge as expertise, that legitimate the adjudicative task of courts, is lacking in AI. Because AI does not have knowledge of the law in the same sense that court has, then even though their results might be just, these results lack of legitimacy. So Hercules and Socrates can produce decision by, but of course the counter objection is the following. Well, Hercules and Socrates can produce decision by analyzing a large number of relevant legal sources in considerably less time than their human counterparts, ensuring correct interpretation of legal materials. Augmented justice can use both probability calculus and explanatory device to determine the most epistemically justified decision about the facts of the law. Augmented justice computational power places it in a privileged position regarding the crafting of adjudicative decision, because they have access to all this knowledge, and they can also use quote unquote this knowledge to crafting decisions. So if knowledge as expertise is the proper use of legal sources and relevant information to obtain just decisions, then augmented justice exhibits this kind of knowledge, extending the scope of legitimacy to its decisions. I mean, presumably can do it better if knowledge as expertise is the grounds for legitimacy, and expertise is just basically knowing how to use legal materials to decide. We can say that augmented justice is better suited to use these legal materials. So therefore, I mean, we don't have particularly strong arguments to not extend this idea of legitimacy to decisions of augmented justice. But wait a minute, you might say, okay, that might be the case, but what about morality? And I know here I'm playing a bit with fire, because we might have moral anti-realists in the house, but bear with me, I'm not a moral realist, but I'm just saying, like, if we concede the worry that morality might play a role in legal decision making and morality might exist, then we have good grounds to try to reject augmented justice. How? Well, I mean, the core of the moral of this objection is that moral considerations are central in our decision-making processes, adjudication being one of those processes. Humans are especially situated to obtain moral knowledge, so the knowledge of what is the right thing to do. Therefore, human courts are especially situated to apprehend what is the right thing to do when adjudicating. AI cannot access moral knowledge, therefore AI is not specially situated to apprehend what is the right thing to do when adjudicating. If this is the case, then we should abandon augmented justice, because they can simply grasp this moral content in this way that human courts can. Of course, this has to do this position, or this objection buys in a lot of commitments, among them, for instance, an anti-positivist reading of the law, or the idea of that there is such a thing as morality, so that there are moral facts, there is this moral reality. So this objection from morality can be advanced in two ways as an anti-positivist reading. So they can say, like, well, you know, look, augmented justice can never adjudicate properly, because law and morality are conceptually connected. So moral knowledge gives insights to legal knowledge, and legal knowledge is a necessary portion, or is necessary for adjudication. AI cannot obtain legal knowledge, so moral knowledge. So because of this fact, immediately gets disqualified to actually know what the law is. So how can you say that adjudicates, right? This is a bit problematic. Or you can simply say, like, look, I'm not an anti-positivist, I'm actually legal positivist, but I can still talk about morality or this idea of value reasoning from a legal reasoning reading. What does it mean? Well, you know, practical reasoning, or the process, the reasoning process to decide what to do is one of these core concepts is moral reasoning. So we reason about values, about what is the right thing to do, and legal reasoning is a dimension of practical reasoning with specific things or specific features. But still, the fact that legal reasoning is a parcel of practical reasoning also tells us something about the place of moral reasoning within legal reasoning. I mean, and this is something that legal positivists, for instance, will be happy to say, like, sure, we use moral values when deciding, when adjudicating, but of course, these moral values do not say anything about the criteria of membership of a legal group. But we still try to reason what is the good way to go about this. What am I supposed to do? What is the right way to interpret the law? Those are can be understood as moral considerations, and AI cannot grasp these moral considerations. So even if engages in this sort of reasoning, it's always going to be insufficient. But of course, the counter could be the following. Well, I mean, if the problem is a moral epistemology problem, then we need to try to figure out how are we supposed to obtain moral knowledge, and the portion of knowledge, or the field of knowledge that deals with moral epistemology, is metaethics, right? And we would like to know what metaethical views say about obtaining moral knowledge. So and see whether this way of obtaining moral knowledge, if possible, it's also available for human courts. So in metaethics, you have two big camps: non-naturalism and naturalism. Metaethics being the field of philosophy that studies morality, right? So moral realism is the view that there are moral facts, that those facts are mind independent, and then when we speak of these facts, we're actually describing reality in the same way that we can describe a table or any other empirical facts of the world. And you have two different ways of understanding this moral realism. You have non-naturalism, that they say that moral facts exist and they are of the same kind. They are not of the same kind as empirical facts, but they are facts nonetheless. But because and they are not of the same kind because they don't live in the world, in the physical world. They exist on a non-natural realm. So that's why they cannot be perceived with our senses in the same way that or other kinds of facts. So moral non-naturalists, they say that, well, we can obtain moral knowledge by using our intuitions. So they favor this epistemological view called intuitionism, that claims that our moral intuitions, or these immediate judgments that bypass our senses, can grasp a moral reality. But of course, one of the big arguments against intuitionism is an argument from queerness, from Mackey, that claims that, well, I mean, morality might exist, but if the way that I'm supposed to know moral reality is having this sort of intuition machine in my brain that, by the way, we cannot find it anywhere, and there's not empirically proven that we have this sort of intuition machine, then I need to buy a very weird, that's queer, right? A very odd way of obtaining moral knowledge. It's so odd that we don't use intuitions to obtain knowledge from the world in any other aspect of the world. So I don't think that this is the best explanatory, like the intuition machine is the best explanatory account of moral knowledge. So I would not be so worried, a proponent of augmented justice would say, because, well, if you are a non-naturalist and you're asking me to believe that humans and human courts have this specially fine-tuning organ that no one has ever seen, then I don't know, there's not much credence to this explanatory view. You have a very weak explanatory framework about moral knowledge. So in this scenario, neither courts nor AI can attain moral knowledge. So it's not much of a problem. We can extend the same argument of morality or objection of morality to human courts and to AI. But if you're a naturalist, which is a view that claims that moral facts can be reduced to empirical facts, and we can learn about them in the same way that we learn about the world, being by theorizing about morality, so the best scientific theory about morality, then we can actually obtain moral knowledge if you are a person, because, well, people obtain knowledge of stuff all the time and can produce it, and courts can also be part of this. But of course, the proponents of augmented justice would say, well, if theorizing about morality is a way, if obtaining knowledge of morality is a way of theorizing and learning of our practices or observations or even experiments and all this knowledge, well, guess what? augmented justice, it's even more powerful than human courts to actually process this. So there also are in this idea of well standing or better standing than human courts to obtain moral knowledge. So if obtaining moral knowledge is the result of this theorizing, and it's just that, well, augmented justice also can do that, and maybe it can do it even better. So actually this morality objection doesn't fall. The third one, it's what I call the BBB objection. It's two-pronged argument. It's called the black box and the bias. So detractors of augmented justice might say, well, you know, we have this problem that AI reasoning is opaque, so we never know how they get to their decision, what kind of factors influence their outputs, and why the system produces specific outputs. So even if Hercules and Socrates can justify their decisions, we cannot know whether that justification is what actually motivated the reasoning. This is the first prong. The second prong is like, well, and also we do know that bias might potentially affect AI decisions. So when you can, and bias, of course, is something that goes against justice, so it undermines justice. So when you combine both, the BBB objection is basically says that since we cannot know how augmented justice arrived to decisions, we cannot rule out that those decisions are potentially the result of biases. If augmented justice cannot rule out biases, then its claims to justice in adjudication is undermined. So this is an epistemic objection in which me, as someone that will read or will in some way observe a decision made by augmented justice, will never be in a good place to actually rule out whether this decision was affected by biases because of the black box objection, right? So I don't have good reasons to believe that that specific decision is a just one, because I cannot know whether if the most motivation advanced by augmented justice was actually were really the inputs that the software used. But of course, the counter is the same. Right? Courts are also affected by the BBB. So we have this, there is this long-standing worry of rationalization of judicial decisions advanced by legal realists, saying that, well, courts, they decide over a hunch. It's very like intuitive. They cannot control it. It's mostly some sort of a feeling even. And then that decision is being rationalized and like dressed as the result of the application of legal principles and rules. But yeah, you never know whether that actually is what the court says that is the reasoning process that is actually the reasoning process. And this mirrors this very famous distinction between the context of discovery and justification advancing philosophy of science, right? in which this idea that the context of discovery is where we kind of come up with the ideas, and the context of justification is all this testing process of validating these ideas. In law, usually it's typically to say that the context of discovery is how we come up with our adjudicative decision, this idea of the hunch, and then the justification is how can we actually validate this decision. And we can always focus on the context of justification, but the context of discovery, which is the black box, it's always going to be something that we can never access to. So, I mean, for the proponents of augmented justice, I would say, well, yeah, the BBB also affects courts. By the way, biases. This is a phenomenon rooted in human psychology. So yeah, courts, human judges being human, they are also affected to these biases. We also know that they're implicit. So you might even do not know that you have a bias. And if we're going to be nitpicking, AI cannot be affected by a bias per se. What can be the bias is the result of the prompts that the human user attaches. But since AI does not show any sort of psychological structure in the same way that humans do, they cannot be affected by biases. But courts can, and also they have the black box problem. So yeah, this is not a good objection either. And lastly, we have a lack of accountability. People might say like, well, you know, augmented justice ought not to be preferred to human courts because unlike human judges, they cannot be made accountable for wrong decisions. So accountability nowadays is a key institutional design of the rule of law and Western legal systems, and courts are made accountable by designing legal mechanisms that can either remove judges from their seats or convict them for special crimes incurred whilst exercising the authority of their office. Socrates and Hercules cannot be held accountable. Thus, the legal system will lack a response to counter potential miscarriages of justices. The danger of unaccountable adjudication undermines the rule of law, providing a powerful reason to reject augmented justice. Right? But of course, the counter will be like, well, it seems unclear how Socrates could be affected by it, because at least in the way that it is presented, Socrates just recommends a decision, and ultimately it's the court, the ones that has the ultimate authority to take it or leave it. So accountability still rests within the court. Now, Hercules is a different matter. And to counter this, the proponents of augmented justice kind of can focus on the nature of the accountability objection, which it could be spelled out as a contingent, as an institutional design contingent to a specific legal system. I mean, historically, we have had unaccountable judges. Now we have, or a legal system without a system of accountability of judges, in the way that modern legal system has. And also, modern legal systems have this, make judges accountable in modern legal systems are very, very difficult, and for very specific scenarios that most of the times never happen. So ultimately, since we can imagine a legal system or adjudication without accountability, we can just say, well, if institutional design is the problem, why not design mechanisms to prevent or to counter wrongful decisions made by Hercules? I mean, it is compatible to use augmented justice with a legal framework that addresses the same concerns about accountability measures. So it's actually not a proper proper objections. So the question is like, did we run out of reasons? And then we are all like super afraid of this. Can I still say something against AI? Well, I think we can. I mean, even if we remove all these objections that they might be plausible, we can still have this intuition that maybe we should not. There is something that might tell us, or a worry that might tell us, maybe we ought not to do it. And part of the paper is to figure out how can I answer this? I don't think I can answer in this paper, but what I can say is that, well, this kind of puzzlement about what is actually what bothers, it's what I call the adjudicator's puzzle. It can help to try to clarify our thoughts about potential or about certain problems that augmented justice can bring about. And one possible way of using the adjudicator's puzzles is by re-examining the relationship between justice and adjudication. And here I advanced 3 possible views, and with this I'm done. So I'm sorry if I went through the time, but we can, looking the adjudicator's puzzle, we can figure out at least 3 ways, or reformulate 3 ways, in 3 ways, the relationship between justice and adjudication. We can have a reductionist approach and simply just say just decisions equals justice, period. That's it. It's very procedural in nature. But if this is the case, then substantive considerations are irrelevant. So we can still have justice or just decisions, that they are equal to justice, and bothers us and say like, well, this doesn't actually seem just, right? Or there must be a substantive element, but from the point of view of adjudication, the substantive element might be irrelevant. And this is very similar to the discussion of why am I supposed to be moral? There's also a whole debate in metaethics of like, okay, let's say if we're able to find what the moral content is, and it turns out that the Nazis were right all along. Maybe I don't want to be moral if that's the price that I pay. I could be moral, or I could just simply do something else. I mean, in this case, we can actually have decisions that they feature these 2 elements, which is correct interpretation of the rules and ascertainment of truth, and say like, and go against a bunch of moral intuitions. These decisions might also, for instance, affect minorities, right? Or the powerless in a society. And you can still say, well, even though you have found the truth of the facts and also you interpreted correctly the law, we can still have problems with this. So that is the first thing. That is the first thing that we need to have in mind if we reduce just decisions to justice. We can have an orthogonal decision in which justice is independent from just decisions. Just decisions serve to high order values other than justice. Justice is there's no place for justice in adjudication, which is kind of odd and also provocative, right? But justice maybe is a matter of some political decision making, but not in law, or even a legislative level, but not in adjudication. Or simply would say that the relationship between justice and adjudication is incompatible. And justice requires substantive considerations that the notion of just decisions fails to capture. And with that, I just want to say thank you, and I'm looking forward to hear your thoughts about this. And this is the paper. Thank you very much.
Thank you very much, Sebastian, for a great and interesting presentation. Let me just find the clapping hands. Yeah, we're a bit behind the schedule with time, but nevertheless, we can open the floor for discussion. Anyone who wants to give comments or pose questions, there's been a lot of content here, so I guess a bunch of stuff is left open. So if anyone is interested, please raise your virtual hand and I'll give you the floor.
Can I shoot first, since I'm going to be offline in some 10 minutes and I can just
Sure.
ask a few questions. It's a great presentation, Seth. Thank you. So I was very interested in hearing your thoughts about this. Also great parts of the presentation, especially picking and choosing whether you have a Socratic or a Herculean artificial intelligence, which is very interesting. I'm kind of worried about a couple of things, and those are the things that you were mentioning. Basically, one, the first thing is the robustness of the hypothetical. What I seem to see in the hypothetical is that you're kind of there is a bit of combination of the current capabilities of artificial intelligence and the perspective capabilities or the ideal capabilities of artificial intelligence. I don't know if you can detect it, but for example, you're presupposing a lot of stuff. For example, that the artificial intelligence is LLM based, which would entail a plethora of things like the inevitability, basically, of calculation of hallucinations, which can be translated into human psychology as, for example, gaps or biases or logic errors or memory errors and so on. The second thing is kind of, for one part, you're approaching with your example singularity, basically. And who is to know if you're approaching singularity if in the idealization of the artificial intelligence? I'm kind of worried whether it makes sense to put any of the objections to the any of the four objections that you kind of imagine that can be given to this justice system. And it seems to me that the hypothetical revolves a bit around between these constrained limits of LLMs or current generation artificial intelligence and some presupposed singularity that we'll achieve at one point in which the artificial intelligence supersedes the human capabilities in every way, shape, or form. So I think it would be a good idea to, well, when you turn that into a paper, to make kind of to choose between these sides, either to take more into account the current capabilities of AI or just disregard the capabilities and go entirely with this imagined AI that would solve all the problems, or at least be AGI, for example. Take one definition of AGI, being better than a human in all relevant respects, and start a thing from there. I mostly agree with your conclusions in the sense that I don't see many problems when you put stuff in this way. I don't see many problems, and I think that all these capabilities can be refuted. I was very interested in the part where you were speaking about moral legitimacy of decisions, because you were invoking basically mathematical theories, but I was wondering whether they are relevant, because what we do expect from judicial decisions, even if we are, for example, jus naturalis, God forbid, jus naturalis, we would expect outputs to be just. At least it seems to me that we are not so much interested into whether the judge that's rendering judgment is a moral person. I don't really care. He might be the shittiest person on earth, as long as he renders a just judgment. And then we come to the question, how do we, what's the best way to guarantee that will be rendered the just judgment? And in many accounts, that would be following a conception maybe of justice, some procedural justice, and so on. Only in some accounts, for example, virtue ethics, you would say, yeah, okay, a piece of shit judge cannot render a just judgment because he's just, as a matter of character, not a good person, and so on. So I'll stop there. Those are kind of questions, suggestions that I had in mind given the time.
Thank you, Boyan. And I apologize for going overboard, but also in my defense, we started like 10 minutes later. So, so do you think, because of course, when crafting the scenario, I don't need to commit myself to LLMs or LRMs or anything. I can just simply go and say, like, look, finally we are achieved to AGI, and AGI has all these features, and that's it. But something that it wasn't kind of clear to me is that you mentioned that if I use LLMs, if I just say at least, then it's inevitable to have AI hallucinations, right? Is this correct?
Could be that they are going to solve it. I'm not quite sure, but it's in definitely the first part of your answer. I get it completely. So if you kind of say we achieved AGI and give a strong definition of AGI, then that is absolutely enough. Might be that this architecture is limited when it comes to when it comes to solving some of these problems, like the hallucination problem, like the high price of compute, in the sense that you would have to cover the entire earth with processors in order to make it work as a human brain, and so on.
So yeah, okay, I understand, because in the paper, these practicalities, even though they help to make the case more plausible, they are not necessary for the argument, right? So I need to kind of get rid of stuff that will complicate more the understanding. I'm not saying that we ought to have augmented justice or we will have augmented justice. I'm just saying, like, look, imagine that we actually have a tool that can think better than us in a high rate and a higher rate, maybe not even 99% of the time, but I just wanted to go to the extreme. So in that scenario, it's better to frame it as a singularity possibility, right?
Yeah, I think so, or at least a very strong AGI.
A very strong AGI, yeah, because I don't need to commit myself with if it is a singularity or scenario, but I can just say a very strong AGI.
Absolutely, like in all capacity is better than a human, but that brings into question the second thing that I was mentioning regarding morality. So
But I agree with you. I mean that's the whole point of the counter of the proponents of augmented justice. They say, hey, you don't need to be human to get the best result, to be the best morally based result. Which one, of course, we can still have a discussion whether morality and justice are connected in some way. So everything that is the moral result is also a just result. I mean, it could be the case. It's not clear. There's also people that say, like, well, justice is a manifestation of morality. So morality is even broader than that. And 100% I would agree that, well, you don't need to be a good person to get good results. And I guess that's kind of one of the counter arguments defense if you're a naturalist. They say, like, well, if you want to obtain moral knowledge, will lead you to justice via theorizing about law, which is basically kind of, in some sense, creating explanatory models of all this data. Well, this AI can do it better than you, can theorize better, right? So we can have it. There's no problem. So I guess I might need to fine tune to this idea of whether morality is part of justice or not. I mean, I can just assume, because the whole point of the paper is to say, like, well, you can have everything that you want, but we still might have good reasons not to have it, right? And that's the whole. And then the exploration, I think, okay, what would those reasons be? And this is where the whole kind of exercise goes in. But thank you very much. That this was very, very helpful, Boyan.
Okay, thank you. And anyone else? Mila?
Thank you very much for really interesting presentation, which was super clear. So despite the fact I don't know almost anything about AI, if we exclude ChatGPT and my usage of it, I understood almost everything. But I have a question, like qualificatory question. How you're imagining the court process to look like with your like avatar Socrates and Hercules, meaning that, I mean, court process involves a bunch of decisions before the final decision. So will, in your imagination of, in this thought experiment, will you have any humans until the final decision, which will be made by AI, or all the decisions will be made by AI? So for example, I'm imagining witnesses or parties coming to explain what happened, why they arrived to the court, and who will be asking the questions, and whether AI can do such a job, and or that should be left still to the humans, and then based on the transcripts of the questionnaires and the answers, you have a final decision made by the AI.
This is a great question, because I didn't think about it. Like, basically, it's like, how would, let's say we have it, let's say we adopt it. How would how would the legal process look? This is very cool, because I can't just say, like, look, in the same way that I'm talking to you now, just I can give, like, I can talk to a microphone and just to the computer, right? And they can render my explanations, then there can be some sort of transcript thing. I mean, do we actually, if we are able to have this thing, do we actually need courts? I mean, presumably, maybe we would still need lawyers, but I don't know, maybe even lawyers will not be a good thing, because we are kind of have these shortcomings. This is very problematic for us as lawyers. Then what are we supposed to do? Maybe we are learning how to program this, or maybe we learn how to prompt, and that we're going to become prompters more than lawyers. But I can definitely either, imagine, for instance, now in Chile, we have a lot of virtual process. We don't have any more paper things. So you just upload everything on PDF, all the pictures, all that goes into a PDF file, all the lawsuits, everything goes to a PDF file, the evidence also, except at the moment where you need to adduce them when is the hearing. But still, one might say, like, well, I can do that if I have enough cameras. Why not? This is, I really like it, because then I can, this is actually could be some sort of part of the conclusions to say, like, well, I mean, adopting these mechanisms will also require to rethink the role of legal practitioners, right? And
yeah, because that's, I mean, that's what came to my mind. I mean, for example, maybe like court practitioners can be completely replaced by AI, because if court practitioners are there to like draft final decisions which needs to be checked by the judges, etc., that can be completely done by the AI, with avoiding all of these problems which you mentioned. Then the AI will just serve like to more efficient procedure, with judges in the end deciding the case.
Yeah, so for instance, Socrates could be only Socrates, right, instead of Hercules. And I think reasons, but then the reasons, for instance, to keep human courts are of different nature of actually the justice of decision making, because it's going to be done by AI. It has to do with some sort of semblance of legitimacy or semblance of accountability. right? I mean, at some point you might say like, well, you as a court, someone should have checked this other thing, and then the judge could be this checker, this overseer. But ultimately, the quality of the content will be left still to Socrates, right? Socrates is the one that will say like, well, look, I've listened both parties, saw the evidence, I collated it with all this that we know about, all these books that we know about property law, and all these books that we know about justice, and this is a decision that is most justified in terms of the facts and in terms of how you ought to interpret the law in this particular case, in light of what was being discussed, right? So the judge might say, well, it is a tough position for the court to say like, well, I'm going to decide something completely different. I'm going to disregard what you have said, because you're like, well, but you have this thing that he's using actually all the knowledge available. What do you bring to the table? But then I think the answer is, well, is institutional design. Is this checks and balances? It's something other than the content of decision, which is a bit problematic, because we would like to have courts that also do something. I mean, there's a point why these people have power that they have, right? Because either they're more knowledgeable, they spent a whole career studying, and now the question will be like, well, what's so amazing of having immediacy, right? Of having all these hearings. I mean, what do you want in the end? Well, I want to have a proper good decision, right? Okay.
Yeah.
Can I just follow up on this? I won't take much of time, but it was you've covered a lot. It was really interesting. I'm not sure how you're going to manage with this many assumptions in a paper. If I understood, it's going to be a typical size paper, right? 20 pages or so.
Yeah.
Yeah, because I wanted to bring you back a bit to the assumptions. If I recall correctly, you were talking about ascertaining truth for facts. I mean, true enough or whatever, and correct interpretation. And then you said according to the interpretative codes and so on. And then it was kind of in the back of my mind, the assumptions. Of course, the putative objections are probably strong, but putting that aside, I was thinking about the arguments and the counter arguments. And I was wondering, especially with regard to morality and legitimacy, about the question, what do you presuppose when it comes to the role of judges in this sense? Because I guess it would be plausible or somehow intuitive to assume what most legal systems do, or what the common view on adjudication is, which is that it's an application of law in the sense of its connection to morality, not requiring to go beyond it and seek justice. I mean, you've mentioned this, of course, in the last slide. But if you take that assumption into consideration, perhaps these arguments might be different. I don't know.
I guess it depends on what you think, because so true, an argument of legitimacy is an argument of acceptance. Why am I supposed to accept this thing and therefore be duty bound to follow this thing, right? Yeah. And different ways of going about this. What I think is the most plausible explanation, at least, is not that I'm posing that this is the legitimacy ground. I'm just taking all these other people saying, like, we have a bunch of people discussing of this. They say that this knowledge, I will take this as such. Okay, let's go knowledge, right? So knowledge as expertise, basically how to deal with all these things, fine.
Yeah, AI fits perfectly there. Yeah,
that we don't have a problem. But then we talk about morality, right? And you ask, well, but I mean, judges are supposed to apply the law. They don't have anything to do with morality or even justice. So I don't know. I don't know what is this problem. Well, this is the interesting part, because if you and this is why it has the morality objection has the same core. Mainly, humans are better suited than anyone else, any other beings, to obtain moral knowledge. AI is not suited to obtain moral knowledge, so we have an advantage here. But why would that be important? Well, if you are an anti-positivist, if you believe that law and morality are connected, then when you apply the law, you are applying morality, right? So because morality
with
and the law
such a strong assumption, okay.
Well, I mean, you're an anti-positivist. There are very good reasons to be an anti-positivist. There are very good reasons to not be an anti-positivist. But if you're an anti-positivist, and by the way, think about how judges speak, they talk about justice, they talk about morality, they talk about what's the right thing to do, whether they are anti-positive or not. Maybe they don't know it, but they use moral language.
Of course.
So if I'm saying that this is the right thing to do, is because I need to back it up in somehow. How? Well, because I thought and I try to obtain moral knowledge. But even if you're not, an anti-positivist, because you might, and I agree with you, this is too strong. This is, I don't think laws like this. I'm a legal positivist.
Yeah.
Still, when we talk about practical reasoning, which legal reasoning is a version of it, we do tend to agree that values play a role in our reasoning, in the sense of like, what is the best way of which is the best way of interpreting this particular legal formulation? Should I use the should? This is a should-ness. Or should I use the teleological argument because it will follow certain problems that we want? Or should I use this other kind of the meaning of the text one? So these are values, right?
Yeah, sure, but isn't that solved through positive texts if you assume that there are interpretative codes which will lead the adjudication in this sense?
Well, you use the interpretative code, but the interpretative codes typically do not tell you which rule to use. So they give you a bunch of options, right? And also, by the way, you need to interpret those options. When I say I'm going to use the intention of the legislator, what do you mean by intention?
Yeah, okay, yeah, sure. There's always more. Yeah, okay.
So, but in this more, it's where value reasoning enters. So what you don't want to be is in a position as if I ask you, but why did you use this one instead of that one? And you say, because I value more this one than the other one. Okay, but do you value it because it's the right thing to do, or it's just a preference in the same way that I prefer chocolate over ice over vanilla? Like, if I want to have a proper answer, I should anchor it in morality, right? It's not what I prefer, it's what is the right thing to do, right? So still we might still have an argument to say like, oh, value/moral reasoning play a role when interpreting the law. Basically deciding this sort of way of going about it, which is the typical thing of practical reasoning. So,
sure, it can make sense. I'm just kind of thinking about it. Perhaps I feel as if it requires precise landscape canvassing before it, or precise assumptions which would kind of distinguish.
So for instance, one of the assumptions that I do is like, which are basically truisms, so they are kind of widely accepted. It's just well, legal reasoning is a parcel of practical reasoning, and practical reasoning at its core, it's moral reasoning. So so this is the sort of things. Now, of course, what I need to say, for instance, I think at the beginning of this objection is to say like, well, imagine that you're a moral realist and you believe there is such a thing as morality. By the way, methodetical view of moral realism is the most powerful one that it is now.
Sure.
The anti-realism is a problem one. It's a problematic one. But one of the things that the moral realists have is that, or that you can do, is like, well, you can make a distinction between something being determinate to something being determinable. So morality might be a determinate thing. We might kind of know what it is or what we wanted or why is it good, but it might be very difficult to determine or to make it determinable. Like, and this is where you can grab this, right?
That was my argument also.
This is the counter argument of the proponents of augmented justice. Well, if your problem is moral epistemology, like that you can actually access moral knowledge and the AI don't, let me tell you something. It depends, right? So that's kind of the idea.
Sure. Okay, it makes sense. I'm just saying, making it precise will really give much quality to the argument.
Very much, I know that these are I'm still kind of like bullet pointing a lot of the things.
Sure. Of course. And maybe just two more clarificatory questions shortly. I couldn't remember if you touched upon the prompts element within the assumptions of your thought experiment. Did you just exclude prompts as an human influence on AI, or was it?
In the thought experiment, it's like, look, you have unsupervised machine learning scenario in which you have access to all these things, but particularly. I mean, maybe
Okay,
prompt
okay.
in a very general way is to say like, well,
Yeah.
you know, you're gonna have access to the database of all legal philosophy, or you're gonna have
Yeah,
access
yeah,
instead of like cooking recipes, right?
okay, 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 okay.
That's
So no human input in this sense, because it would complicate things a lot. Yeah,
yeah,
definitely.
yeah.
Sure,
I
sure.
agree.
Okay, and lastly, with regard to accountability, I was wondering what you actually meant by it. Were you alluding to, I don't know, appeals and the layers of the process, which would mean that another AI could probably change or revise a decision, or did you mean something with regard to disciplinary
I mean, how can you
control?
discipline AI? I mean, that's a problem. So
Yeah.
the core of this objection, what I try to use it to diffuse it is that, well, you know, accountability is not within the concept of adjudication, right? It's a
Okay.
different something that we put on top of it. So
Okay.
if this is true, if my reconstruction of the accountability objection as some sort of institutional measure is true, you might just say, well, if that is what bothers you, then let's try to think of some other institutional measures that can correct cases in which AI might decide wrong. What could those measures would be? I do not know.
Yeah.
That's the good part. Because you
Yeah.
might actually have the question like, do we need appeals?
Yeah.
If you have a system in which 99% of the times is right, do you need
Yeah.
appeal? I don't think so. But you might need something else for that 1%,
Yeah.
right?
Yeah.
So,
Or you needed a completely different system that would appeal or something else. Yeah.
or something else, Do you have a second, like a meta AI? This is a good question, actually. This is a good question. That's why
Like
I leave it to
Hercules
you.
Pro.
Huh?
Like Hercules Pro for a second.
Yeah, Hercules. Yeah. So at the beginning, I thought to call it Justice Plus, instead of Augmented Justice. But then
Yeah.
maybe it's like, well, if you want Hercules, you can get one decision. But if you have Hercules Plus, you get one decision plus the appeal.
Yeah.
Something like that. But
Yeah.
but I mean that's the idea. So that's why I said that it's kind of a weird paper, because in legal philosophy we don't tend to use thought experiments.
Yeah.
So this is more of a kind of, I don't know if you have read, for instance, What is to be a Bad, or The Brain in a Bad, sort of scenarios.
I have.
So kind of elicit this intuition.
Yeah.
But I don't
No,
know.
it makes
I hope
sense.
it works out.
I wouldn't even say that we don't use thought experiments. They might just not be so explicit.
Maybe you're right. Maybe you're right.
Yeah.
I want to be very explicit to say, like, look, this is a scenario.
Yeah.
Whether it is plausible or implausible, that doesn't matter. It's just like, look, what if we can get everything we want? Maybe we have still good reasons to not want this. Hence, it was a shame, because I hope people smile when I show the slide of Jurassic Park, but it was very good. So this was one of the things that made me think about the paper. Like, I was watching the movie and I was like, this sounds awfully a lot like AI. So then I was like, well, maybe there's something there.
Yeah. Sure. No, it's excellent. I'm looking forward to reading the papers.
Well, thank you very much, and I apologize again to move to.
No worries, it was fun.
My thing, but it's the first time that I presented this. I just finished writing it 2 days ago, so I was like kind of figuring out how to use it. And thank you very much. I like the clarificatory questions, and also.
Oh, we have one more question in chat.
Oh yeah.
Suggestion. Yeah, you can read it.
Mirna. Okay, via message. So, suggestion for some to read AI snake oil. Okay. You're welcome, Mirna. I'm writing your recommendations. I'm actually do not know much about AI, which would be great. So that's why I did not know kind of the technicalities, but I'm just assuming, like, look, you can even, I think you can even use it without AI. You can just say, imagine that we can just have everything we want.
Yeah.
Like, can we actually not doing it? Now AI seems to be the most close thing to say, like, that this is a possibility now. So it has more weight or impact, but learning is fun. Thank you very much.
Great. So thank you for being with us. We will, of course, hope to welcome you again at our Belgrade Legal
hopefully in
Theory
person
Group.
sometime soon.
Sure, of course, especially after things settle in Serbia.
Yeah, fingers crossed. Fingers
Yeah,
crossed.
thank you.
As soon as possible.
Okay.
Well,
So
Saba,
that's
Mila,
it.
Mirna, thank you very much for everything.
Likewise. Hope to see you
Bye.
soon.
Bye
Bye.
bye.